This a big up, this one's for Greg. Straight from the rain and every Jimmy and Red. Him a reggae lover, the real Dan Dada. Pinny this champ and the bike race.
A Day at Trust Class, Day 2. Author Bard, Justis. Chapter 10, Day 2, Diving Deeper into Trust Administration. Miss Hamilton stood in front of her class, ready to continue exploring the fascinating details of express trusts. Good morning, everyone. Today we're going to dive even deeper into express trust administration. Yesterday we talked about the structure and purpose of the trust. Today we'll focus on how to administer it effectively, following WEISS'S CONCISE TRUSTEE HANDBOok. The students looked ready for another thought-provoking lesson. Let's start with the idea of administration, Miss Hamilton began. According to WEISS, the administration of an express trust under common law requires us to take a unique, hands-on approach to managing assets while ensuring that the trust remains independent and private. Footnote 21 mentions that the trust has its own juridical personality, meaning it can act as its own entity. This is important because it allows the trust to enter contracts, hold assets, and be protected under law just like an individual would. Chapter 11. The Principle of In Rem Jurisdiction. Miss Hamilton noticed that Alex had a question. What does it mean when we say the trust acts as its own entity? He asked. That's a great question, Alex, Miss Hamilton replied. One of the key ideas in express trust administration is in rem jurisdiction. In footnote 24, WEISS explains that in rem jurisdiction means jurisdiction over things rather than over people. This principle ensures that the trust property is protected by common law, preventing outside parties from gaining control over it without due process. The class leaned in, listening closely. To put it simply, she continued, the trust retains control of its property as long as the trust instrument and corpus, which is the property within the trust, remain under the trustee's care. WEISS highlights that if a third party wants to intervene, they would have to follow a formal legal process which protects the trust's assets from arbitrary claims. Tom raised his hand. So as long as the trustee manages the property correctly, no one can take it away. Precisely, Tom. This protection ensures that as long as the trustee abides by the declaration of trust, the trust's assets are secure from interference. Chapter 12. Handling Income and Expenses. Now let's talk about managing income and expenses within the trust, Miss Hamilton continued, moving to a new section. One of the key responsibilities of a trustee is to handle finances transparently. WEISS explains in footnote 29 that managing income, paying taxes, and handling expenses are essential to trust administration. This is where trust accounts come in. Jamie raised her hand. Are these trust accounts like bank accounts? Yes, Jamie, but with a twist, Miss Hamilton replied. Trust accounts are separate from personal accounts. They're used solely to manage the trust's finances, ensuring a clear distinction between the trustee's personal assets and the trust's assets. WEISS emphasizes that this separation is critical. It protects the trust's assets and prevents commingling, which could weaken the trust's legal standing. Miss Hamilton added, and remember, the trustee is responsible for keeping records of all income and expenses. Footnote 33 stresses that detailed record-keeping is essential for transparency and accountability, as these records show that the trustee is acting solely in the interest of the beneficiaries. Chapter 13. Certificates of Beneficial Interest. Let's revisit something we touched on briefly yesterday. Certificates of beneficial interest, Miss Hamilton said. These certificates are unique to express trusts because they allow the trust property to be divided into shares, much like a corporation. However, unlike corporate shares, these certificates are private and don't grant ownership. They simply represent the beneficiary's right to benefit from the trust. Rachel raised her hand. So it's like they own a part of the trust's benefits, but not the actual property. Exactly, Rachel, Miss Hamilton nodded. Footnote 34 explains that these certificates allow beneficiaries to receive income generated by the trust property without holding legal title. It's a great way to distribute benefits while maintaining the trust's privacy. And because these certificates are private, they don't have to be registered with any government agency, preserving the trust's independence. Chapter 14. Equity and the Duty of Care. Miss Hamilton moved to a new topic. One of the principles that guide trust administration is equity. Equity is all about fairness. In footnote 20, Weiss explains that equity compels the trustee to fulfill the trust's purpose honestly and diligently. This is known as the duty of care. Jamie asked, "Is that like the fiduciary duty you mentioned yesterday?" "Yes, it's part of the fiduciary duty," Miss Hamilton replied. "But the duty of care specifically requires the trustee to act with a level of responsibility and caution, almost like they're managing their own property." Weiss describes this duty in footnote 61, emphasizing that trustees in express trusts must act prudently and avoid unnecessary risks. She added, "The duty of care also means that the trustee must avoid conflicts of interest. If a trustee is ever faced with a decision that could benefit them personally, they have to prioritize the trust's interests over their own." Chapter 15. How Equity Protects the Trust. Equity doesn't just protect the beneficiaries, it also strengthens the trust itself, Miss Hamilton explained. When a trustee acts in good faith, following the trust's purpose, equity protects the trust from being undermined by outside forces. Tom raised his hand. So equity makes sure the trust is used properly. Exactly, Tom. Footnote 13 explains that equity compels performance, which means that as long as the trustee acts in line with the trust's purpose, the law will support and protect the trust. This is why express trusts have such a powerful standing under common law. They're treated as private contracts, protected by the principle that no law should impair the obligations of a contract. Miss Hamilton saw the students nodding along, absorbing the importance of equity in maintaining a trust's integrity. Chapter 16. Protecting the Trust Through Jurisdiction. Here's something important for trust administration, Miss Hamilton continued. In an express trust, jurisdiction matters. According to Weiss in footnote 8, the jurisdiction of the express trust should ideally be within a common law system, like certain U.S. states that respect the trust's independence. This protects the trust from statutory intervention. Alex raised his hand. So where the trust is set up affects its protection. Exactly, Alex, Miss Hamilton replied. The express trust should be set up in a jurisdiction that respects its structure under common law. Some states offer more protection by not requiring trusts to register or report to the government, preserving privacy and independence. Weiss emphasizes this in footnote 14, where he explains that the trust's protection relies on where and how it's established. Chapter 17. The Power of the Trust Instrument. Finally, let's talk about the trust instrument, Miss Hamilton said. We've discussed this a bit, but it's worth noting just how important it is. The trust instrument, often called the Declaration of Trust, is the document that establishes all rules, roles, and responsibilities. Weiss describes it in footnote 15 as the heart of the trust. It's the ultimate reference for any action taken within the trust. Rachel asked, "So as long as the trustee follows the instrument, everything should work out?" Miss Hamilton smiled. "Yes, Rachel. The trust instrument gives trustees a clear roadmap. It details the trustee's powers, the beneficiary's rights, and how the trust should be administered. Footnote 20 explains that if the trustee follows the instrument faithfully, equity will protect their actions. This keeps the trust's purpose intact and prevents misinterpretation by third parties. Chapter 18. Final Reflections on Trust Administration. As the class wrapped up, Miss Hamilton summarized the day's key points. Today we learned that the administration of an express trust is both powerful and protective through in rem jurisdiction, equitable principles, and the strength of the trust instrument. Express trusts maintain a level of independence and security that's unique under common law. She paused, looking at her students who were deep in thought. Remember, each part of the administration process is about keeping the trust private, independent, and secure. By following WEISS'S guidelines, trustees can ensure they fulfill their duties while safeguarding the trust's assets for the beneficiaries. Jamie raised her hand, her face thoughtful. So, as long as everything's done right, the trust is almost untouchable? Miss Hamilton nodded, a smile forming. Exactly, Jamie. That's the power of an express trust. It's structured to withstand challenges and preserve the settler's wishes, all while respecting the rights of the beneficiaries. With the bell ringing, Miss Hamilton watched her students leave, reflecting on their newfound understanding of the intricate process of trust administration. The express trust, a formidable and well-protected legal tool, was beginning to take root in their minds as more than just a theory, but as a true example of legal ingenuity.
Trust tax go down. Trust tax go down.
Yo, Mr. Smith, you're here to contest the county's tax on that property address. It's held in a trust, private and lien. No business, no state ties in between. Yes, Your Honor, that's my scene. This property's private, if you know what I mean. No minimum contacts, it don't mess with the state. Just chillin' for beneficiaries, no tax on the plate. Minimum contacts, but that's for real. The county says property tax is a bill. They claim location sets jurisdiction tight. Doesn't matter if it's trust or spotlight. Respectfully, Judge, let me take it back. International shoe set that contact track. In Schaffer v. Heitner, it came through. Location ain't all if contacts are few. Alright, I see, you're throwing down law with precedent sharp like a courtroom saw. But if it's in the county, do the taxes apply? Mr. Carter, county's lawyer, you wanna try? Thank you, Judge.